Hello.
Hi.
How you doing? Are you screen recording already? Okay. So, here's a long rant. It's going to be multiple things here. But anyways, because Oklahoma has no jurisdiction at all, there are no state remedies to exhaust. Therefore, writ of habeas corpus is the only way to attack this wrongful conviction and unconstitutional incarceration. Defiant Against Injustice is a YouTube channel on a platform with millions of channels. The subscriber base is less than 1,500. There is a near zero chance a person would come across Defiant Against Injustice by accident. On stand, Megan testified that her boss, Amanda Robison, had seen the video on Defiant Against Injustice's channel and let Megan know. Robison was not there to verify this, and James Thornley did not raise objection to the hearsay nature of this testimony. Imagine a jurisdiction statute that was so brazenly unrestricted that a channel on a streaming service makes content that is offensive to a certain type of criminal, and every criminal guilty of that crime that came to the channel to watch that type of content then has jurisdiction in the state and county they happen to be standing in for whatever grievance they have about the content they chose to go to and then chose to sit through. It was not sent to them by anyone associated with the channel. There is no way that this is how jurisdiction is supposed to work. Prosecution's assertion that Graham versus State and 22 OS SEC 121 would apply jurisdiction this liberally and flippant. Ridiculous interpretations and misrepresentations like this are littered across every document and verbal argument Joe Freeman has submitted to or asserted to the judge and jury. Due process. It is a basic principle of due process that the enactment is void for vagueness if its prohibitions are not clearly defined. Furthermore, as a matter of due process, no one may be required at the peril of their loss of liberty to speculate as to the meaning of the penal statute. Oklahoma Constitution 222, liberty of speech and the press, saying that speech is not to be abridged in any way, form, or fashion. Hogner versus State is an Indian case law that says that if it happens in Indian territory, it's they have jurisdiction over it because Congress made the reservations their own land, and considering that Congress has not dissolved those in any way, form, or fashion, then they have jurisdiction. Same thing with Texas. Texas was established as a state, and it has jurisdiction over its people, and Congress has not issued anything to dissolve or delete the existence of Texas as its own sovereign jurisdiction, so Oklahoma does not have jurisdiction over this matter. Of what little evidence was presented in my felony charge under 21 OS 1173B in an alleged violation of F2, course of conduct H of that statute, which states sending to the victim any physical or electronic material or contacting the victim by any means, including any messages, comments, or other content posted on any internet site or web application. Contacting and sending to being the operative words in H, which I will testify to my grave I did not do. I did not contact anyone protected under the order, nor did I in any way send anything to anyone protected under Judge Rogers' order. I was never accused of by anyone that I had asked anyone to contact. Oh, shit. It's like a damn juggling act holding all this shit up while I'm doing this. I was never accused of by anyone that I had asked anyone to contact or send anything to anyone protected under Judge Rogers' order. Not one part of H or the protective order was violated in any piece of the evidence presented. The charge has a line that under F1 and F2 that states constitutionally protected activity or conduct that serves a legitimate purpose are not included in course of conduct or patterns for harassment. Not one person under oath testified that I had posted the video. Megan said her boss sent it to her, omitting that the video had been posted to the YouTube channel Defiant Against Injustice 4 months prior to her reporting it to her husband's friend in the Durant Police Department, whom overstepped Durant Police Department's announced conflict of interest to put charges in place with no more investigation than watching several minutes of the video sworn under oath. He didn't have time to investigate further or inquire about Defiant Against Injustice as to any of the details of the existence or posting of the video. The video had been posted for 4 months. What are the chances the video would inspire imminent lawless action and would likely to produce such action? Answer is 0. Imminent doesn't mean 4 months from now, and considering the video was not directed to or at anyone protected under Judge Rogers' order, nor did I or anyone send the video to anyone protected either. There was 0 violence mentioned in any way in the video. Defiance Against Injustice is not a kid's YouTube channel. It has a very small subscriber base, and I would wager a hefty sum that it did not come across anyone's feed in this case, and it was instead sought out. Megan Colleen Henderson testified that her boss, Amanda Robinson, had seen the video and told her about it. I have 0 clue who this woman is and cannot fathom how she could have ran across this tiny channel in a sea of 51 million channels without being directed to the channel. I can say that in my years with Megan, I personally witnessed her stalk mine and her ex's pages throughout the entirety of our relationship. She has or had multiple accounts for multiple platforms with fake names. She is the stalker, and transcripts from hers and Robert Henderson's protective order hearing would show that I couldn't post anything without them claiming it was to them in some way. A post I had made that was just 111 got used against me. Another Facebook post said, if you're dancing with the devil, don't be surprised if you find yourself in hell. That got used against me. Take a little quick recess while I set some stuff down here.
Those got used against you in a misdemeanor?
In the protective order hearing. Hold on.
Oh, okay.
In the initial protective order hearing where, Rob Henderson's protective order hearing that I won and Megan's protective order hearing that I lost in and that I'm alleged to have been violating right now.
Okay.
Okay, so... Oh my goodness.
It's okay. You got 21 minutes.
I know. Okay, so I have scoured the law library for anything that steals jurisdiction on, as prosecution has with Graham versus State, and reading every case I can find nothing that says it's so loose with both personal and subject matter jurisdiction. The video was neither directed at nor sent to the alleged victim, and prosecutors' assertion that the crime is consummated wherever the alleged victim was standing when she chose to go to the channel Defiant Against Injustice and watch a constitutionally protected video with not even a hint of a threat of violence, implied or otherwise, directed at judges, detectives, officers, jury members, and prosecutors, claim that Lon Meeks was talking about crimes the alleged victim had committed against him and his condemnation of those actions. This is exactly how freedom of speech is supposed to work. Brandenburg, no chance of imminent lawlessness. 4 months from an editor posting it to alleged victim watching it. In every instance of 22 OS SEC 121 being applied, there is a sender and a receiver, or intend to send to or submit to. Assault, violence from one to another, murder committed to another, documents submitted to or created with the intent to send to. In every instance of this statute I can find, it seems since the inception, which there are very few, there is no attempts to grab so abusively as Joe Freeman has at jurisdiction in this matter, and my assertion of judicial bias due to Judge Campbell being mentioned in the one and only piece of evidence submitted in this charge. He overruled a 44-plus-year attorney's objection to jurisdiction, constitutionality, and lack of the elements being proven, as H requires a send to when nothing was even alleged to be sent to anyone, and nothing anywhere said could not speak about the alleged victim. As Freeman kept saying, his bending of words, like saying that the video was directed at alleged victim when it clearly wasn't, or saying that Judge Rogers ordered defendant couldn't speak about alleged victim when no order said such thing, to judge, jury, and submitted to the clerk, breaking the law in the exact manner as he is claiming the defendant did by submitting fraudulent, misleading, perjurous statements created in Pushmahata County and submitted to Bryan County. And I am certain will play cutesy. That wasn't his intent, as he also repeatedly accused the defendant of to the judge, jury, and filings to the clerk.
Woo! So good. So good.
Okay, hold on. Oklahoma does not have personal or subject matter jurisdiction over this matter. Nothing was ever alleged to happen in Oklahoma. No one disagrees that the video was created in Bell County, Texas, where two near identical charges were dismissed in the interest of justice. Prosecutor asserted that 22 OS SEC 121 was the vehicle through Graham versus State to rob Bell County of its jurisdiction. This was a malicious and a reckless abuse of the important part prosecutors played, leading to a gross miscarriage of justice. I have read every case associated with 22 OS SEC 121, reading all footnotes and all headnotes, and nowhere could I find any contemplation of this being applicable in my case, as Joe Freeman so recklessly asserted in court to Judge Campbell when arguing against the 14th Amendment. Judge Campbell's bias and abuse of power was clear in this ruling, and the same level of failure to keep his clear bias in check was apparent in his overruling of the constitutionality of the video evidence that was submitted, that he later ordered me to destroy as a condition of my eventual parole. Judge Campbell's lack of impartiality was mentioned in the video. I had spent years married to the alleged victim, who was a paralegal with deep ties to the legal community in Durant, so I had some insight into the assumed whys of his ruling. Judge Campbell should have recused. Oklahoma Code of Judicial Conduct, Canon 2 states a judge shall perform the duties of judicial office impartially, and Rule 2.11 states a judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned. It is clear that these standards were not upheld in this case, with his ability to rule impartially being questioned in the one piece of evidence presented. There is no way he should have stayed on the bench. On multiple occasions, I asked my counsel to make sure no judges from this area were involved in this case, as the alleged victim had been way too friendly to all of them for too many years. It would take me an hour to explain all the ins and outs of the conflicts that exist in Durant with every person involved in this matter. I am the outsider to a massive friends circle. Durant Police Department announced conflict of interest and passed the investigation of the misdemeanor matter leading up to the felony, where Officer Puana placed charges on behalf of his friend Robert Henderson, the alleged victim's husband. Disregarding the already announced conflict, every lawyer in town refused to represent me. Thornley should have announced conflict also for his ties to Jenna Newman, his friend and former 20-plus year co-worker as the DA and assistant DA, whom tried to bribe me with $15,000, spoke of in the video to accept a lifelong protective order and walk away. Recorded. That's a recording. In short, conflict is rampant in Durant, and there was zero chance for a fair trial. Judge did have a handwritten extra part added to the protective order, and I believe the verbiage basically says I couldn't make a video directed at her, like a letter to her, then read into a video and posted on my page for her to find. Nothing in Rogers' order said I could not speak about the protected people. Clearly in the video, I was condemning the actions of everyone involved in the story of the contract fraud. In the first 60 seconds, the video says who the video is directed at and or to. No protected party was in that list. No violence was even hinted at, and the title of the video said Judge Rogers should watch this. The prosecutor's testimony and my ineffective assistance of counsel's lack of objecting to Joe Freeman's assertions of evidence not on record was the most damning aspect of the trial. Judge Campbell made sure Joe Freeman didn't miss his chance at an opening statement. I am not a low intelligence person. My IQ is around 120. Every perceptive bone in my body said this trial was a modern-day lynching, and my own counsel walked me quietly to the gallows. I told him my feelings about this the day before jury trial, recorded with 2 witnesses. Transcript was attached to the motion to terminate counsel. Joe Freeman downplayed my grievance as a disagreement in trial strategy and asserted Thornley had shown his ability to handle a jury trial and the state's response to a pro se motion to quash, dismiss, and set aside. Thornley has been practicing law for over 40 years, 30 of which was as a prosecutor in Durant. Many of his clients he has conflict with, and he doesn't announce it. He prosecuted Chancellor Reagan, then represented him some years later. Chance fired him in court. He has been fired by countless people over the years. He is a drunk and has little to no professionalism. In my first in-person meeting with him, he informed me that he didn't give a fuck if I was guilty or innocent. Then informed me that none of the context mattered. None of my witnesses mattered, all recorded with witnesses that he said all that. Thornley did the absolute minimum to make it look like he did his job. His 3 points made for a motion to quash, dismiss, and set aside were gold in my book. I thought surely, with his years of experience, maybe he was right, and all the context did not matter because of those 3 very good reasons. 1, constitutionality of the video. It was absolutely non-threatening, nowhere near the Counterman rule, 0 hints of violence. The charge I was facing said constitutionally protected speech was not included in harassment. My video wasn't directly or indirectly at or sent to any protected party. The YouTube channel, Defiant Against Injustice, has a handful of editors, and Officer Puana testified the scope of his investigation into this potentially 15-year felony charge was to just watch several minutes of the video, and he didn't have time for more. No investigation into who posted the video, but prosecutor kept testifying that I chose to post it. No one else testified to that. The person who did post it was willing to testify, but Thornley refused and said it did not matter. I feel before hitting someone with a crime this large, he should have some due diligence owed to the accused. He and Joe Freeman are Masonic brothers to Robert William Henderson and the alleged victim's husband, and former practicing lawyer in Durant before admitting to using street-purchased amphetamines to help him with his caseload on stand under oath. Puana overstepped the announced conflict. Idabel, Oklahoma had assumed responsibility for the investigation. Durant Police Department wouldn't even hear my internal affairs complaint because of the conflict. Sorry for the rambling. It's how my brain works, as seen in the near 40-minute video evidence. 2. Jurisdiction. I am a resident of Texas, and the alleged crimes happened in Texas. Nothing was ever assumed to happen in Oklahoma. Texas had already established jurisdiction over 2 near identical charges that were dismissed in the interest of justice. Joe Freeman asserted in state's response to pro se motion for new trial that Graham v. State 1985 OKCR 36 698 P.2D 25 and 22 OS SEC 121 would apply in this case. Graham committed the perjury and directly had handed those documents being received by the clerk's office where the consummation happened. 22 OS SEC 121 just covers the bases in the event that it is e-filed or emailed or some new technology or app creates a route to complete the from and to dynamic. Directly is an operative word in 22 OS SEC 121. In my time in jail, I have spent over 200 hours digging through a tablet on the wall in the digital law library. Several people have threatened harm on me, and 2 have threatened to kill me for overusage of it, and as it is the portal to the world with around 47 people sharing 2 tablets. Graham was established in 1985 and has never so brazenly been used to violate due process, free speech, free press on a non-violent, non-threatening, constitutionally protected video where the person in the video asserts all that twice in the only piece of physical evidence presented that was not sent to anyone but was uploaded to an adult content YouTube channel that the alleged victim stalks for fear of her transgressions being brought to light. Every protective order, injunction, and charge has been a vexatious litigant committing malicious prosecution to silence the real victim in all this, me. What I said in the video is true, and every drop of this stems from my daughter being kidnapped through contract fraud, and that same fraud on the court used as a gag to silence me about the crimes that John Houston Nix, on behalf of Robert William Henderson, for his mistress and now wife, Megan Colleen Meeks Hartley Henderson, whom in every protective order hearing and police report and testimony always leaves out the prima facie contract fraud that has me screaming on the internet for help or attention for my plight. If any investigating body spent just 2 hours looking into what I am saying, this would be cleared up quick. Meeks versus Meeks, divorce out of Grayson County, Texas. Look at what was pled for and what was signed by judge, with no pleadings in between. Contract fraud, prima facie, and that is where all this begins. State failed to present sufficient evidence. This is 3 for Thornley's things. State failed to present sufficient evidence to meet the elements of the crime. F2, course of conduct H, sending to. Key word, nothing was sent to anyone. No malice was expressed. Prosecutor misused Counterman versus Colorado 600 U.S. 66 2023 as the bedrock to rest his case on. Counterman was telling CW to die. He was sending messages to CW, a person he barely knew. There isn't a glimmer of Counterman associated with this case. The video was never alleged to be sent to anyone, and no one was asked to send it on my behalf. They stalk me and accuse me of stalking them. No other non-hearsay evidence was presented in court, though. The protective order, in my humble opinion, was void in abnitio, as the fraud on the court that spurred the charges that spurred the protective order was omitted. Megan tried bribing me to accept the protective order. This story truly is just madness, but I swear to its truth because they have done all this in the manner that they have. It is all prima facie provable. My lawyer Thornley refused to subpoena any of this. All records with the witnesses, the elements were not met. Joe Freeman lied, misled, misrepresented every chance he could to the judge, and more importantly to the jury. Prosecutor introduced his assertions as facts into the record. He insisted at every juncture of the trial that I had chose to post the video, even though nobody had testified to that except for him. That Judge Rogers' order said that I could not speak about the protected people in her order when about wasn't mentioned in her order. He said that the video had slurs directed at the alleged victim. They were about, but not at or to, harassed, has a definition. In this charge, nothing in the video meets that definition and nothing was sent to. Prosecutor then told the jury that I was playing cutesy and that I really knew I was ordered not to speak about and that I was hiding under the Constitution, basically like I was playing dumb. The Constitution is a bulwark, not a cloak. The prosecutor was my most damning witness. His incessant front row testimony to made up facts should have him disbarred, as he seems to have gone out of his way to make sure a justified innocent man from outside his jurisdiction is now unconstitutionally incarcerated in Bryan County Jail under Sheriff Johnny Christian, with expectation to catch chain and go to a Department of Corrections facility. If Judge Rogers' order was so clear about its writing to not be void for vagueness, then the prosecutor would not have needed to reword her order to clerk, judge, and jury at every critical juncture. State versus Amador 2024. Also, prosecutor used unconvicted charges as means to prejudice the jury further. Everything stated in the pro se motion to vacate judgment, quash, dismiss, and set aside is my story laid out in a third-person format, but I assert it's true. My writing hand has a screw in it, and this hurts to write. Please release me from custody while deciding on this matter. This has wrecked my family through all of the vexatious and dilatory tactics used against me since the beginning of all this. I have not missed one court date. My son's graduation is coming up, and I would love to be there for it. I also have a 16-month-old son who hasn't seen his father in 2 months. This is the time that shapes them greatly, and the unconstitutional injustice of this is robbing Haven Hart Meeks and Logan Meeks of the early guidance, please, I beg to return me to my family while you make this easy choice. This is a rare case. I just know it. I can't believe our courts are weaponized like this too often and to this degree. Judge Campbell would not allow me to terminate Thornley and wouldn't allow me to have my hands free to navigate my paperwork for my motions. I had respectfully asked, and I have never given reason to believe that I would try to escape. I have exhibited zero violence, just felt less than human while fighting for my rights the way they say I am supposed to in this. That's all I got.
Baby, it's beautiful. It's so good. Can that just be the writ?